Welcome to Marin Voices and Views. With Lawrence A. Strick, I'm Peter B. Collins. Joining us today is Marin County District Attorney Ed Berberian. Nice to meet you.
Nice to see you, gentlemen.
He joined the DA's office back in 1976 as a trial attorney. He was promoted to Chief Assistant in 2004, appointed to complete the term of Paula Kamena in 2005. He won election in 2006, 2010, and ran unopposed in 2014. We're glad to have you here, and you've been in the news a little more than usual this year, faced some controversy over your handling of a case involving road rage and firearms. We'll get to that in a moment. But first, could you please thumbnail your department for us? The general duties, the size of your staff, your budget. Give people a sense of your department.
Well, as the county district attorney, I am, on one hand, a state constitutional officer as a district attorney. There are 58 of us in the state for each county, one for each county. Our total staff would depend on how you identify the staff, whether they're full-time. We have some part-time staff. We have a number of volunteers these days that we rely on. So the total working staff that allows us to do our job is probably around 100 to 110 individuals.
Mm-hmm. All right. And what's the size of your budget?
Again, it's and I haven't looked this year to see where we are. I know it's less. It's in the millions.
Mm-hmm. Okay.
I don't want to misrepresent what it is, so I don't want to guess off the top of my head at the moment.
All
Well,
right.
before we get into the Max Wade case and the Joseph Nassau case that grabbed the headlines, we were surprised to learn recently that the most frequent violent crime reported in Marin is domestic violence. Your office has a family violence division. Can you tell us what you are all doing to address the issue?
Okay. Well, again, and I did briefly before we came on live mention to you that we have to make sure we're on the same page here. When we look at crime in Marin County, and we're probably one of the lowest crime rate counties in the state, if not the lowest, our numbers of crimes, the most frequently ones are often substance related, abuse related, and some property crimes as well. So then when you move away from that and you get to what people usually have their attention directed to is the violent crime. In Marin, our highest percentage of violent crime is in the domestic violence, or what we often call family violence area. Unlike other areas in the Bay Area here where you hear a lot about the gangs, which we do have that issue as well to some extent, still domestic violence has been, almost for my entire tenure in the office, the most prevalent violent crime in the county.
And in both Sonoma and Alameda counties, they have one-stop centers for domestic violence victims. Given that this is a very serious issue in Marin, should we upgrade our response? And do you think that these one-stop centers are more sensitive to the victims and their needs?
Well, in a way, you're mixing a few things here when you talk about that. These are called justice centers, and Alameda was actually one of the pioneering counties in the nation to establish a justice center. And yes, they're to serve victims, but it's not just for domestic violence. It goes across the board for any victim in any category of crime. And the theory behind it is that you put all of the needed resources in one fixed location so that the victim does not have to be moved from one portion of the county to the other or around, even maybe to regions in the Bay Area, to get services they need. And that can be from counseling services to perhaps treatment services, places for daycare. I mean, it just covers the whole gambit of whatever you think a victim needs to be served by. There's one in Sonoma County. There is one, as you know, in Alameda County. And I believe around the state at this point there's about 15 of these justice centers, and it's my understanding there's maybe 5 to 7 that are being contemplated to be added to that number. At this point, Marin has not been identified as someone that you have to look how you're going to support the center from a financial standpoint. And at the moment, we have not been able to put ourselves in a position really to gather those resources together. although I think we serve our victims very well in this county. We have a Health and Human Services Department that has a lot in play and can address some of the issues. We have internally in our office a victim advocates program, our victim services program, where we, particularly victims of violent crime, are serviced there, helping them to obtain state aid and various resources for counseling when they need it. We have good coordination through our state association of DAs in the victim advocacy area, where they have good contacts in each of our counties where they can service victims if they happen to be from out of the area. Mm-hmm. So there's a lot that we have in place. If the question is, would it be good to have a center here? I would say that it would be good to have it. I have to be realistic in saying, where would we put it, and where's the money going to come from to support it? Mm-hmm. And that is one of the issues, because I know I've spoken to Jill Ravitch up in Sonoma County, and they have a good program in place up there. But one of the things that she has to battle with is to keep the funding in place, mm-hmm. to keep it going. Mm-hmm. And that's just a theme we seem to have with a lot of the services we'd like to provide.
Like most cases, most cases resolve. Certainly in my arena, the civil arena, that's true. I would think in your arena as well. And you have a fair amount of prosecutorial discretion to bring these cases. Do you have a set of guidelines that you use when you're looking at domestic violence?
Well, family violence, and one of your earlier questions was, how are we internally structured? And I didn't really answer it at that time, but what we've done principally, well, it started a little bit before I became into office, but we've really concentrated on having a developed team of attorneys that is trained up for handling family violence. I use family violence because it's not always just a spousal type mm-hmm. connection there. You're going to have parent-child issues, you're going to have sibling issues within the family, and they have a lot of the same dynamics. And unfortunately, many times there are children in the homes where these happen, so they are, in a way, not maybe the victim in a physical sense, but they are marked by this. So we have people that have gone through special training to deal with this. And we, again, with the budget issues we've had, it's been challenging to keep a team in place. So we currently have what we are calling a special victims unit at this point, where we're concentrating these trained attorneys, and they're also receiving increased caseload through sexual assault cases and things of this nature that are more than just the straight, what has been traditionally defined as domestic violence.
So Ed, now let's turn to the road rage case that I referenced, and briefly I'm going to recap the events based on the reporting of the Independent Journal. So last July, two 70-year-old men got worked up over a traffic incident. One was Dr. James Simon, who was chased to his home on Paradise Drive by a man named William Osenton. Simon zipped into his garage, closed the door, and Osenton was so close, following him, tailing him, that the door hit the hood of his car. So Osenton was getting out of his car, and then he was hit by a bullet after Simon fired a warning shot from a .357 revolver that he kept in his garage. So you assigned this case to yourself. You charged Simon with attempted voluntary manslaughter and assault with a firearm. At the preliminary hearing, Judge Kelly Simmons ruled that there was insufficient evidence to justify a trial, and that your prosecution, quote, did not meet the bare evidentiary threshold. You then took the case to the criminal grand jury with the same charges. Quoting again from the IJ, the grand jury balked, but given a chance by Berberian to consider lesser charges, signed off on them. On June 19th, Judge Andrew Sweet dismissed the grand jury indictment in its entirety, saying that you had, quote, made an inappropriate presentation to the grand jury that failed to tell jurors relevant details about the case, or told them details that had no relevance at all. The result, said Sweet, was, quote, substantial prejudice. You then took the unusual step of publicly disagreeing with Judge Sweet in an IJ op-ed, which I happen to have clipped here and brought in today, and I'll quote directly from that. I strongly disagree with the court's interpretation of the record and am very disappointed a Marin jury, based on this decision, will not be afforded the opportunity to answer the question of what justifies the use of deadly force to defend oneself. Now, you clearly feel very strongly about this case. First, are the facts as the IJ has related them generally accurate?
For the most part, well, I don't agree with some of the interpretation, obviously, that the judges have put on the record. Matter of fact, I strongly disagree with that. But under the facts, and one of the things I've done, and it's the first time I've ever done this, is, because I do feel strongly about this, is that I've taken whatever is in the public record, both from the preliminary hearing, which is the transcripts of those proceedings, and I've also taken all of the transcripts from the grand jury proceedings, because they are public record, and I have put all of the grand jury exhibits that were presented to the grand jury as exhibits. Those are there, and which would include the photographs, the diagrams. There's some video of the cars that were captured by a Marin Country Day school a little bit before they got to the location where the incident occurred.
And all this is on your website?
And this is all on our website. And if people want to take the time to look at those facts, I believe you'll see that, particularly for the purposes of getting this before a jury, there is more than sufficient evidence there that would support that. As to characterizations about keeping evidence from the jury, if that's what you're reading into some of this, that simply was not done, and that's the reason I've tried to be as transparent as I can under the rules that I have to work under here, to show you what was before the grand jury in particular. And the fact that sometimes is glossed over in this is, one of the things this case was not about is the Second Amendment. This was never, and Dr. Simon was never charged with something that would be categorized as a violation of his right to possess or own firearms. And that's the way it was played oftentimes by those that were not enthralled with my prosecution. They saw this as some challenge to our Second Amendment right to bear arms. My whole reason for going forward was that when I looked at the entire record, and this wasn't something that right after the arrest we made a filing decision. We sat on this for a while and we looked at this, and we went out to the house through various search warrant accesses that we had, and really examined the full, what I believe was a full record of what happened. And when you make that decision to take, and that's what this case focuses on, the decision to have to use deadly force, that it was required in order to protect yourself or your wife in this situation, the need to use deadly force was present. And I think that should have been decided by a jury, not by a single judge or even two judges. I know that the grand jury requires at least 12 of the individuals out of the 19 to find that under the law, in this case, self-defense did not apply. And you will see by looking at the record, if people care to go that far and look at the detail, they were fully informed as to the right to self-defense. They were given complete instructions on the right to self-defense. In fact, I believe they were given instructions more than I was required to give, which Judge Sweet may disagree with, as to the use of some of these self-defense instructions. So they were, I think, given instructions in the law beyond what a court might do in front of a trial jury. But putting that aside, the fact of the shooting itself occurs, and again, you have to look at the record to see all of this. Yes, Mr. Osenton, who's the other individual in this, he's not blameless in this, I agree. And I think he himself has a self-realization that if he did things he should not have done and hopefully would never repeat again.
But you didn't charge him with anything.
No, I did not. And one of the criticisms I got from the court was that he was engaged in some type of felonious conduct. And I think that, again, is an overstatement of what was present. First of all, I have to make a factual finding here, or a factual judgment as to what in an incident is, if there needs to be something addressed, what is the most egregious thing that needs to be addressed. And I looked at Mr. Osenton's conduct. Yes, he did some things he should not have done. No, I do not believe that, maybe in a hyper-technical sense, you could come up with some type of what we call a burglary theory because of the nose of his car being inside a garage, which is a structure. You have to have coupled with that an intent to commit a felony or to steal, and it becomes very problematic whether, when you look at all the facts, what that final evidence would be on his intent to commit a felony at that moment of entry.
But he was looking for a fight, wasn't he?
That's an interpretation a jury has a right to evaluate, I think. But what happens is that garage door, as is reported there, does come down on the front of his car. He never physically enters that garage. He's never physically in that garage. When you look at the photographs, which are part of the stuff that's out there on the website, you'll see that that garage is, it's got a solid wood door. There's no front buttons to access it by just pushing a button. The only access is that you then have to go through a gated area, which was off to the left, and proceed down a walkway, make another turn, come in through a rear door, which has only a key access from that outside with a small porthole type window on it, and the only access with some type of a twist use of your hand is from the inside, where Dr. Simon was.
So your argument is that he was well defended.
He was
didn't need to use a firearm.
At that point, he did not need to use the firearm, which was he had in a non-secured location in that garage, a loaded .357 caliber weapon. And the other thing that needs to be looked at in detail, if people care to do that, is the statements he makes. And this is where I was, again, criticized for using what was called impermissible character evidence, which I, again, disagree with. He had a state of mind of wanting never to be a victim because of an experience that he had when he was in medical school decades ago, where he was the victim of a violent crime type incident, a robbery. And that has played on his mind over the years. And he repeats that. The police don't know about this, and he talks to them about the incident and tells them, before I say anything to you, let me tell you about this. And he goes to this incident. So to him, that was a very strong focus for why he was doing whatever he was going to do. And in fact, in his statement, if you go through it, you'll find a second portion of it where a year or two prior to this incident, he made some type of a driving maneuver that angered an individual on Paradise Drive, who then followed him into his driveway. It wasn't the same thing to the extent that Mr. Osenton got out of a car, as I recall, but that incident there put Dr. Simon in the position where now I'm going to take one of my guns that I have in the house and I'm putting it in this location in the garage. So, I mean, there's a lot that was bearing on him in his state of mind. He could have stayed in that garage. We do have in California, and it was argued that, hey, we have a no retreat situation.
Is that stand your ground?
Well, basically, it's a type of stand your ground position. My interpretation of that is that, yes, you do have a right to stand your ground. You don't have to run away if somebody necessarily is directly confronting you. My position is he moved himself to a position where he didn't need to. He didn't need to advance out of that garage, make those path turns to go to that gated area that Mr. Osenton never went into. What we call, the attorneys know what a curtilage is around a structure. He never broke that curtilage, that interior area that's more protected. Dr. Simon goes to that gate, opens it, goes outside, and then that's where the shooting takes place. Mr. Osenton did not have a firearm. He did not have a knife. He did not have a bat or any other type of deadly weapon at that time. We know from the medical treatment and examination he had that the wounds he received were actually in the side, not directly as if he was advancing at the moment he was shot. So that material is there in the physical evidence. But again, you get into this emotional thing tied to someone's right to have a gun. And he had over 40 to 50 different firearms. in his house and some in the garage. He had several hundred boxes of ammunition for these items. He could have gone, if you again look at the path and the photographs, from that back door into his house. Now, if Mr. Osenton, and these are not the facts, but if Mr. Osenton had breached that gate, had gone in, had continued to advance in an angry fashion, that would be a different fact situation to evaluate. And the whole basis of using self-defense is that your decision and to use deadly force has to be a reasonable one under the circumstances at the moment you decide to potentially take a human life. And that's what I think a jury had a right to decide. What is our standard? Is it all right to take that extra step to take a human life? And we're extremely lucky that it did not happen here by the narrowest of margins.
It seems to me that this controversy's come. It's certainly got a lot of play here in Marin. You've made your comments public in the IJ. Do you feel that it'll have an ill effect from the bench to your office as you go forward with prosecutions?
I know that I would not do anything differently if I'm faced with the same situation in the future and we have the same type of factual situation. You got to wait and judge each case on its own merits. So I can't say we will have one, and hopefully we never do. But and I can't just make my decision that I believe I'm charged to make by taking polling numbers with the public, because if I did that, I would have never gone forward beyond the preliminary hearing. Nor do I believe that I have polled the judges for what might happen. I would hope over the many years I've been here that they know that I do believe in the integrity of doing my job in an ethical way, and I do. And no, I'm not. It's a decision I had to make. I will continue to make those decisions, and I respect our court enough to know that they are professional and hopefully would recognize that.
I'm sure you read the letters to the IJ.
As a matter of fact, as I told you off the air, no, I do not.
Oh, not the letters. I was talking about the comments online.
Comments.
That's the real ugly stuff. Well, let me just quote from a couple. James Quigley, San Rafael. One particularly laughable sentence from Berberian caught my eye. Dr. Simon, in the minutes before the shooting, had secured himself in a place of safety, had armed himself with a loaded firearm, and had access to a telephone to obtain law enforcement assistance. And snarkily, he writes, here's a shorter version of what he wrote. When seconds count, the police are only minutes away. So he's saying that the exigency of the circumstances should prevent any kind of second judgment or review of what Dr. Simon chose to do.
Well, with all respect to, what was his name?
Quigley.
Mr. Quigley?
Mr. Quigley.
Mr. Quigley, if he goes to the record, he will see that that decision to have to use the deadly force didn't have to occur at all because he was locked and secured there. I mean, again, he had to advance to put himself into position to where he was directly confronting the person that he was in fear of. So
here's a supportive
I don't
letter.
think it was a reasonable decision to leave the garage. Is the bottom
Jeffrey
line.
Gale in Novato writes, shame on Marin County Superior Court judges Simmons and Sweet. They allowed Dr. James Simon to walk in the road rage case on Paradise Drive. And then there's a gentleman who identifies himself as a former district attorney, Mark Epstein, a former prosecutor, let me say, Mark Epstein of Greenbrae, and he says he's unaccustomed to seeing a DA seeking publicity in this manner, and he basically is asserting that you got too personally involved in this case. Do you feel that in retrospect?
I really don't feel that I was too personally involved. And I don't think I've been, quote, seeking publicity in the sense that it would be something that would advance me in any way. As I pointed out, if you were making those decisions based on what could be a polling of what you have heard publicly, I'm probably proceeding in a way that's opposite of reacting that way. I just feel that the public, our residents, have a right to decide when that need to take someone's life is justified. And because it is not a black and white area where the law is 100% clear on what that standard is, I think this was a case that needed to get in front of a jury. to let them speak to that.
Well, thanks for sharing your point of view on this. We appreciate it.
Yeah.
And we have room for a final question from
the
well-dressed Lawrence A. Strick.
We'll get to that in a second. Before we get to that, I really wanted to ask you about court funding. Are the courts in Marin getting enough money from the state to effectively do their jobs?
Well, I don't have access to their books, but I know that they've had severe cutbacks in their funding. We all know that. And this happens to be the week of the summer conference for our DA's Association, and the Chief Justice of the Supreme Court spoke to the DAs yesterday, and we had a conversation with her about the funding issue, just that you've discussed. And without prompting or anything, one of the things that she brought up in explaining how they've had to look at, because of the governor's cutbacks and the legislators' cutbacks and the money coming to them, they've had to look at how they redefine the distribution of monies to the various courts. And she used as an example Marin County.
A good example or a bad example?
Well, from the standpoint of being the Marin DA, or if I was the Marin CEO, I wouldn't like the comments that I heard particularly, because they were looking at ways that there were some counties, because of their population, their crime statistics, their caseload statistics, the way past distribution of monies may have to be readjusted. Mm-hmm. So when you talk about court funding, I see that our county is going to be challenged with that going into the next at least 3 or 4 years, even though there's been some recovery this year, but it's being spread to other places in the state, and Marin is one of the losers in this distribution.
Yeah, all right, you got 20 seconds. Get your fashion question.
Well, I'm really uninterested. There was a big brouhaha at the courthouse recently about a survey of women lawyers and their dress. Did that come onto your radar, and what do you think about it?
It definitely came onto my radar when I got a call from one of my deputies. She had read an article in our Bar Journal publication, newsletter, that had greatly offended her, and after she summarized it for me, I hadn't had a chance to read it yet, I agreed with her that she wanted to respond, and actually she said, I'm calling you because I'm a deputy DA and I want to be able to say I'm a deputy DA at the end. And I said, that's your job. You can say what you want to say.
Actually, she said she was the president of the Prosecutors Association.
That is true. They have actually we have two. The union. We have a union that represents the attorneys from a labor management standpoint. That's actually the Teamsters. And we have a Professional Prosecutors Association, which is essentially the same members, but they can engage in activities beyond just labor negotiations. And she does represent that unit as their president.
I think you're looking very sharp today.
Well, you thank Jerry Garcia.
Ed Berberian, Marin's district attorney.
Okay.
Thanks for joining us today.
All right. Thank you.